Hello friends, welcome back to the third module on Service Operations Management. I, Dr. Sanket Charkha, welcome you for this particular session. To introduce myself, I have completed my graduation and post-graduation in Commerce from Savitribai Phule Pune University. I have completed my Masters of Business Administration, that is MBA, in Finance and Operations Specialization and International Business Specialization from Savitribai Phule Pune University. I have also completed my Masters of Philosophy and PhD from Savitribai Phule Pune University. Currently, I am working as an assistant professor at Sinhagad Institute's Srimati Kashibai Navali College of Engineering, Department of Management Studies, and also a permanent faculty or a professor under Savitribai Phule Pune University. I have 9 years of academic and teaching experience and associated with the various research projects which have been provided by the government organizations. Now let's begin with our learning. In this first module, we'll be understanding and dealing with the concept of meaning of warranties and guarantees. The learning objectives. At the end of this particular session, the learners will be able to understand what do we mean by, or what is the definition of warranty and what is the definition of guarantee. What are the various activities that have been undertaken in respect to the warranties and guarantee. And lastly, what do we mean by how we define a warranties and guarantees and how are they important. Now let's begin with our learning. Initially, we'll start with the first concept, that is a warranty. Warranty, which has been defined under section 12, subsection 2 of the SOGA, that is Sale of Goods Act of India of 1930. I quote, a warranty is a stipulation collateral to the main purpose of contract, the breach of which would give the rise to claim the amount of damages but not reject the goods and cannot be treated as repudiated. So, as per the Sale of Goods Act of 1930, the definition of warranty that has been provided under section 12.2 specifically says that a warranty is a stipulation. Stipulation means a certain amount of condition. So, a warranty is a stipulation which is collateral to the main purpose of contract. So, according to a warranty, this particular contract can be executed, but it is not a mandate but it is not a compulsion. So, which means it is a collateral. This particular contract can be performed or the contract cannot be performed. The activity can happen or the activity cannot happen. So in this particular case, a warranty is a stipulation, but in case of a warranty, it is always collateral, and the collateral is been associated with the main purpose of contract. And if the main purpose of contract is not been fulfilled, it is not been complied, then the breach of contract cannot come into existence. The breach of contract can only be undertaken for the repudiation of damages, and hence the contract cannot be cancelled, which can be called as a null and void. And hence, if any claim arises with respect to the damages, the customer does not have a right to reject the goods, but he can get the services or the goods repaired, and accordingly the services can be rendered. So that's the meaning of warranty. In a case of Sale of Goods Act, the warranty is always having the secondary importance, because in this particular case or consideration, the contract cannot be cancelled, it can be only repudiated, and hence for those particular consideration, the contract is essentially required to be performed, and the goods and services can be repaired, they can be exchanged, but they cannot be cancelled as a part of a contract. So in this case, in case of a certain amount of warranty, only damages can be claimed by an individual, but the goods cannot be refunded or they cannot be cancelled. In case of a warranty, what is the intention, what is the purpose, and what is the objective of a person is needed to be identified, and on those particular basis, the warranty transaction or contract is being undertaken. Now let us understand the various provisions related to the transfer of property and titles under the Sale of Goods Act of 1930. Under the Sale of Goods Act of 1930, the transfer of property and title can be effected by three effects. Number one, transfer of property as between the seller and buyer, transfer of property on the title of sale, and third, the transfer of property on the basis of ownership rights. So in case when we need to identify whether the contract is of warranty or guarantee, one needs to understand what is the movement of transfer of property. The transfer of property from one person to another person is only undertaken when the contract of sale is been completed. So in the first example of the first case, that is the transfer of property as between the seller and buyer. So when a particular seller sells a goods and the purchaser purchases a certain goods, the transfer of property takes place very immediately. And hence, when all the compliances as to contract have been conducted, the property in goods has been transferred only when the payment has been done. The second effect, in case of a transfer on title of goods. The transfer of title on goods in case of a sale of goods act is been undertaken only when the bill is been drawn on the name of a certain person. That is, I or you, we purchase a certain amount of goods and services. The payment is not yet been done, but only the receipt or the bill is been generated. So on the basis of invoice, on the basis of bill, or on the basis of a certain document, the property or the title in goods, or that is the name in the goods, gets transferred from one person to another person. That is specifically from the seller to the buyer. The third effect. In case of the third effect, that is transfer of ownership rights. So in this particular concern, it is a combination of transfer of property as well as transfer on title, wherein the property in goods is gets transferring from one person to another person, that is from the buyer to the seller, or from seller to the buyer, only when the payment in of for the goods and services is also done and the bill is also been generated or it is been created. And hence, in this particular case or situation, the transfer of property and transfer of title is being undertaken in the consideration of transfer of ownership rights. Now let's take an example to understand what do we mean by a warranty contract. So take an example as to Mr. A has purchases a refrigerator from Mr. B, the retailer, who says it is a frost-free refrigerator. But after the consideration and after the use of 6 months of the refrigerator, he finds it that it is not accordingly. So that is, the refrigerator that he has purchased is not frost free after the 6 months it was being observed. And hence, in this particular case, Mr. A cannot reject those particular goods and services. And accordingly, Mr. B can prepare, or Mr. B can only undertake a certain transaction or an activity to repair the damages and not replace the product. And hence, a small manufacturing defect as to changes in the product, changes in the certain commodity is a part of service that needs to be undertaken. So when a particular small amount of service needs to be delivered with respect to the manufacturing defect of a certain product, in this particular case, it's a part of a warranty, and hence it is not a part of a guarantee or a condition. Had it been a certain condition, then accordingly the entire product needs to be replaced. But in case of this particular example, the frost-free refrigerator is been identified. The purpose or the intention of the person is not known, and hence it is an example of an warranty contract. So here in this particular example, the intention is utmost importance, that is for what reason or purposes the goods are being purchased. So unless and until the purpose or the intention of the purchaser or the buyer is not known, one cannot come to a conclusion and understand as to why the goods and services has been purchased and what is the intention for purchase of those goods and services. And hence, for this particular consideration or practice, the intention of party needs to be known, and accordingly the contract needs to be conducted. Now let us understand the differentiation between the condition and warranty. Number one, condition is always essential to the main purpose of contract. That is, because of this, the contract cannot take place, or a particular activity or transaction or the sale of goods and services cannot take place. And hence, condition is the main purpose. Whereas warranty is collateral to the main purpose of contract. Collateral in the sense, it is an additional condition that has been laid. The condition may be must be fulfilled, but a warranty may be fulfilled or it may not be fulfilled. Distinction number two. The aggrieved party can repudiate the contract and claim damages, or in both cases of breach of contract. So, if any breach is been arised in terms of a condition, the aggrieved party can claim the damages also, as well as he can cancel the or get the product replaced and refunded. So, in a place of a certain condition, both the considerations are applicable in case of breach. But in case of a warranty, the customer or the purchaser can only claim the damages of the particular goods and services, but he cannot refund or get the goods replaced. The third distinction, a breach of condition can be treated as a breach of warranty, whereas in case of a warranty, a breach of warranty cannot be treated as a breach of condition, because warranty is collateral and not compulsory or as a mandate or part of a condition. So here in this case, warranty may be fulfilled, may not be fulfilled, whereas the condition needs to be fulfilled as per the Sale of Goods Act, which is into existence. Now let us understand what are the various exceptions as to the conditions and warranty. In case of a condition and warranty, the first exception is fitness for buyer's purpose. Always, it needs to be identified that when the transaction of the purchase and sale is being undertaken between a purchaser and seller, that is a buyer and seller, the fitness for the buyer's purpose distinction says that the goods that have been delivered or the goods that have been sold should always be fit for consumption to the particular purchaser. And accordingly, the goods whatever we are purchasing, always the buyer and always the seller has to rely on each other that they are fit for consumption and fit for the purpose of the buyer. And hence, if such goods are not been observation, then accordingly it is a breach of warranty and the goods can be rejected or the goods can be get as a part of it replaced. So here there is a case study which the students or the learners can refer as to Manchester Linears versus Ria Limited. So you can please refer this particular case study and accordingly you can understand about the concept of fitness for buyer's purpose, in which the product that is been delivered by Manchester Linears was not fit for the usage of the Ria Limited, and hence there was a certain litigation matter and the court has given a certain decision. So that is the conception or the exception with respect to fitness for buyer's purpose. The next exception to this particular rule is merchantable quality of goods. So here in this case, a particular person who is selling certain goods by description is bound to sell the goods of the merchantable quality only. So depending on the description that is given for a certain product, it is the duty of the seller to sell only those products which resemble to the maximum amount of sample. And the quality of the goods should also be merchantable. That is, it should be able to sold out in the open market and everyone should accept that product as per the description. So if the goods are not of the merchantable quantity, they cannot be used and hence the buyer can reject those goods and services. So it is very essential to identify whether the goods are either the composition of the condition or whether they are the composition of warranty. Now let's take an example here at this particular stage. That is, you went to a particular shop and accordingly you asked for a hot water bottle. And the retailer has shown you a certain bottle in which it was been specified that the water remains hot for several point of time or for a certain period. But when you start actually using those particular bottle, it was been observed that the water does not remains hot. So in this case, we can say that the bottle that you have purchased is not of the merchantable quality, wherein it is the main purpose or it is the main condition that the water must remain hot for a certain time period. And if the water does not remains hot in a particular bottle, then you can say that the goods are not of a merchantable quality and hence it needs to be rejected or replaced. So in this case, the condition as to merchantable quality of goods is not been complied or not been fulfilled and accordingly the goods can be rejected. Now let's understand what do we mean by implied warranty. Section 14B of the Sale of Goods Act deals with the consideration as to the condition of implied warranty. The first condition that has been provided is the condition as to quiet possession, wherein it is always assumed that whether the particular person or the particular purchaser who has purchased a certain goods or commodity or a service, he has the possession as to the quiet nature, wherein the full permission to use those particular goods and services is been provided. So that's the concept of quiet possession. That the next second implied warranty as to the condition is section 14C, which tells about the consideration as to free from encumbrance. Here in this case, encumbrance means free from any charge. The goods that we are purchasing from buyer or the goods that we are purchasing from the seller and which has been bought by the buyer should always be free from any charge. So there should be no charge on certain goods and services and you should always have a clear title. And if the title is very defective, then accordingly the same defective title gets passed on to the buyer. And hence, free from encumbrance is a particular consideration as to implied warranty, that everyone assumes that the goods will not be with a certain charge and the goods are free for usage. The next implied warranty is quality and fitness for usage at international trade. So whatever goods and services that are applicable or that have been purchased, they should be always of a certain qualitative nature and their fitness for usage in the international market should be acceptable. And hence, only then we can say that the implied warranty as to quiet possession and the free from encumbrance is into existence and the goods are available for the purchasing and selling in the international market. Disclosure of the dangerous nature of the cause. So it is an implied warranty which takes into consideration that the seller must always reflect the disclose the dangerous nature and cause of the goods and services. So if the goods are of the hazardous nature, then accordingly the seller must inform the respective buyer that's to the dangerous nature of the certain goods and services, and accordingly all the information must be given to the buyer. Now let us understand what do we mean by guarantee. So according to section 126 of the Sale of Goods Act and a certain composition of the Indian Contract Act, a contract of guarantee is a contract to perform the promise or discharge the liability of a third person in case of his default. So here in this case, a contract of guarantee is of a certain consideration wherein one party is taking the liability of the another person. One party is agreeing to discharge the liability of some another person in case the particular party, or that is the third party, performs a certain default. So if default arises, then only the contract of guarantee can comes into picture, otherwise there will be no contract of guarantee. Now let's understand what are the various parties in a guarantee contract. There are majorly three parties in a guarantee contract. The person who gives the guarantee is called as a surety. In the person in whose respect guarantee is been given is called the principal debtor, and the person to whom the guarantee contract is been given is called the creditor. So in this way, there are three parties who are been associated in a guarantee contract. Number one is surety, number two is a principal debtor, and number three is a creditor. Now let's take an example to understand what do we mean by a guarantee contract. Now, in our consideration, a guarantee contract can be either a written agreement or it can be an oral agreement. So, in form of a certain consideration, the guarantee contract can be written in a certain format and a particular signature of the parties, that is, the surety, principal debtor, and creditor can be taken, or between the mutual agreement of certain parties, it can be a form of oral contract. Now, let's understand what are the various features of guarantee contract. The features of guarantee contract also considers that all the essential elements of a valid contract have been fulfilled. The essential elements of valid contract are minimum two parties, lawful object, lawful consideration, the legal consent, competency of parties, not specifically declared void, certainty and possibility of performance, and so on. So what are essential elements of valid contract are being provided under the Indian Contract Act, are being complied, they have been fulfilled, and only then we can say that a guarantee contract can come into existence. The next perspective or the feature is minimum three parties. In a particular guarantee contract, it is essentially required or as a part of a mandate that there must be minimum three parties into the guarantee contract. And those three parties are the principal debtor, and the creditor. So in this way, that is the person who is the surety is called the first person, the principal debtor is the second person, and the creditor is the third person. So these are the three parties that are involved in a guarantee contract. In case of an guarantee contract, it is the basic essential need or a requirement that there must be an existing debt into existence. So whatever contract that has been conducted for a part of a guarantee, it should be only conducted for the existence of debt. If no amount is due or if there is no existence of debt into consideration, then here in this particular case, guarantee contract cannot be conducted. Default of the principal debtor only. So a guarantee contract can exist or it can come into force or it can be implemented only when the principal debtor commits a certain fault. So if there is a default at the part of the principal debtor, then only the surety can be held liable and the amount can be recovered from the guarantee contract. So on the basis of the contract or the condition that has been laid in terms of the guarantee contract, the principal debtor should be unable to pay a certain sum of money or should be unable to perform his promises. So if it is been observed that the principal debtor is at default, then only the surety can be held liable and the creditor can recover a certain amount of money from the principal debtor or the surety. The next feature of the guarantee contract is the guarantee contract can be of any type. Either it may be a oral contract or either it may be a written contract, and hence from those particular perspectives any one form of guarantee contract can be into existence. The next consideration is some consideration is essentially required. So one of the major feature of the guarantee contract is the involvement of money as a certain perspectives. So in terms of a guarantee contract, consideration is essentially required and there should be an amount of money that is into existence. So consideration as to what is the value for that particular contract, and the value of the contract should be very specific, should be definite, and should be a specific concern. Not only relates to misrepresentation. So another feature of guarantee contract is here in this case there should be no misrepresentation between the parties who are into existence. So whatever parties are included in a certain point of contract, all the parties should be competent, should have an equal consideration, and there should be no misrepresentation or miscommunication as to the performance of parties in a certain contract. Now let us understand what are the various types of guarantee contract. The first example is retrospective guarantee, which is the retrospective guarantee is a type of guarantee contract which is given for an existing debt or obligation. So if any amount is been due or to a certain person to be paid, then a retrospective guarantee can be undertaken. So for a particular consideration wherein the existing debt is into existence and obligation between the parties is continuous or ongoing, then for those particular perspective, the retrospective guarantee can be undertaken. The prospective guarantee. So in case of an prospective guarantee which has been undertaken for a future debt or for a future obligation. So if in a future tense it has been observed that at a certain future date a certain debt can arise or a particular person is unable to pay, then for those particular consideration the future debt or an obligation as to prospective guarantee contract can be entered. The fidelity guarantee. So the concept of fidelity guarantee states about an undertaking that has been given by a certain person for the conduct of his business. So a particular person for his good conduct or for his good behavior, the guarantee contract can be given. So in terms of the Indian economy, we have various concepts as to Zamin. So for those particular consideration, the fidelity guarantee is being provided by different people. The fidelity guarantee should always be given with respect to the judicial authorities, either at the district level, either at the state level, either at the High Court or the Supreme Court level, or at the Taluka level, that is the judicial magistrate first class. So this particular type of fidelity guarantee is been given with respect to a certain individual for the conduct of good behavior or for his good performance in the future. The next perspective or the specific guarantee. So a type of guarantee contract which is given for a specific contract or for a single debt or for a single obligation. Such type of contract is called as a specific guarantee contract, wherein only for a single transaction or only for a single activity the guarantee contract can be undertaken. The next perspective or the type of guarantee contract is continuing guarantee. So a particular contract which has been undertaken for several number of transactions or several number of activities, such type of contract is called as a continuing guarantee. The number of series of transactions can be conducted, and wherever the guarantee is being given under the section 129, then such type of contract is called as the continuing guarantee contract. Now let us understand the concept of revocation or termination of a guarantee contract. So a revocation or termination of the guarantee contract can be undertaken under section 130. So under section 130, the notice to the creditor can be given, and accordingly the surety or the principal debtor can revoke or terminate the guarantee contract. Usually the guarantee contract is being terminated by the surety on if he feels that he wants to get relieved from the contract. Section 131. Section 131 of the Sale of Goods Act deals with the consideration as to the death of surety of a particular person. So if the death of surety occurs with respect to a certain consideration, either to the natural death or the accidental death, then accordingly the surety automatically gets discharged from his particular liability, and accordingly the guarantee contract gets terminated. Section 133 deals with the consideration as to variations of contract. So initially, when the contract was being signed, the creditor, the surety, and the principal debtor has signed a particular contract. And if in case it has been observed that there is a certain variations in terms and conditions of the contract, then accordingly, on the basis of variations of contract, the surety can get discharged from his respective liability. And accordingly, if it has been found that there are major or a more number of variations, then accordingly the principal debtor also gets terminated or revoked from the guarantee contract. Section 134. It deals with the release of the principal debtor. So if in a particular case or a certain situation, the principal debtor makes a certain amount of payment and accordingly there is no amount of which has been due or an obligation which is pending, then on the basis of release of the principal debtor, the guarantee contract gets terminated automatically and it does not exist. Section 135 focuses on the compounding of the principal debtor. So if there are more number of principal debtors which are into existence, that is there are 2, 3 or n number of principal debtors, and when all the principal debtors gets compounded together, then on those particular basis also the guarantee contract can get terminated. Section 139 deals with the Creditors Act. So, if in case a creditor conducts any activity and a particular activity which is not provided or not permitted as per the Indian Contract Act or as per the Sale of Goods Act, then here in this particular case, on the basis of Creditors Act, the contract of guarantee can be terminated. Section 141 deals with the creditors losing its authority. So, if in case it has been found and observed that the creditor in the particular guarantee contract is losing its authority, the creditor moves from one place to another place and it has been moving its respective activities and transactions, then on those particular basis, the guarantee contract is being terminated and accordingly, all the parties to the contract are being relieved. Section 143 deals with the consideration as to the consideration of invalid contract. So, if by a certain virtue of nature of law, it has been found out that the contract becomes invalid, then on those particular basis, the guarantee contract gets terminated. And lastly, failure of co-surety. So if there are more number of co-sureties into existence, so on the basis of failure of co-surety, the guarantee contract automatically gets terminated and the parties to the guarantee contract are also relieved from their respective responsibility. Now let us understand what are the various rights of surety, that is, the person who is providing a guarantee contract. The rights of surety against the principal debtor are the right of subrogation, that is, to make a payment on behalf of the principal debtor. The right to claim indemnity, that is, to recover a certain sum of money from a particular principal debtor and hand it over to the creditor to get relieved from the liability. So accordingly, if the principal debtor makes a certain amount of payment, then accordingly, the surety has a right to get relief from the liability, which is either of a continuing nature, which is of an ongoing nature, and so on. So these are the various rights of surety against the principal debtor. Now let's understand what the various rights of surety against the creditor. So against the creditor, the surety has a right to benefit a certain amount of security. This particular security is to be provided to the principal debtor and accordingly, hence, the creditor cannot take any action against the principal debtor because the surety has preserved or reserved the rights for the claims that has been under its existence. Claim of set-off. So if it has been observed that the payment for the creditor is not been done by the principal debtor, and in this particular case, the surety can come forward, make the necessary payment and set off the whatever dues that have been there with respect to the principal debtor. And hence, claim settlement system can be undertaken by the surety against the creditor. And lastly, exoneration, that is only on due date. So the rights of surety can be of a certain nature that the rights can be existing or can be arrived only on the certain due date, which is also called as an exoneration. So unless and until the due date for a certain payment arises, the right of surety against the creditor cannot be raised. The next perspective is rights against the co-sureties. So the right of sureties that are also associated against the co-sureties if there are more number of co-sureties who are into existence. So there may be several number of sureties, there may be several number of principal debtors, and there can be only one creditor into existence, and hence the right against the co-surety is also into existence. Now let us understand how a discharge of surety from liability can be undertaken. Number one, by revocation. So the discharge of surety of liability can be undertaken by the notice or by death of surety. So a proper notice can be given by the principal debtor or the creditor, and accordingly the surety can be relieved from his liability. And second perspective is by the death of surety. So if the surety itself dies or a certain natural death occurs to him, then accordingly on those particular basis, the surety gets relieved from his liability. By the conduct of creditor. So on the basis of certain activity that is been undertaken by the creditor. So when we say that the discharge of surety from his liability, either by the revocation or either by the conduct of the creditor, is amounting to how the surety can get his liability discharged and in what sense the surety of liability can be discharged. Now let's understand by the conduct of creditor. So when there are certain changes in the terms and validity of a particular contract, then accordingly the surety can also get discharged from his liability. The second point is by the release of principal debtor. So when the principal debtor that on whom the particular amount is due or is to be paid, if he gets relieved from a certain liability, then accordingly by the conduct of creditor also, that is when he receives a certain amount of money, then also the surety gets discharged from his liability by the security that has been lost by creditor. So if a certain amount of security is been given by principal debtor to the creditor, and if the creditor loses that particular security, then in this particular case also the surety liability gets automatically discharged. And lastly, by invalidation of a contract. So if a contract becomes invalid by the virtue of law or by certain unenforceability concerns, then in those cases also the surety gets discharged from its liability. So in an overall scenario, we can understand that the contract of guarantee is a certain amount of promise, wherein one party is promising to save the person's life. Wherein in case of an warranty, it is a type of contract which encompasses the amount of due which has been undertaken, and if the goods are not as per the contract or not as per the quantity that has been specified mention, then here in this case the contract comes cancelled. So the guarantee encompasses the product, the service, the people, and the customer satisfaction, whereas the warranty simply covers the product and not any other perspectives. And hence the warranty is provided without any charge, and hence it is called as it is a collateral to the main purpose of contract. So if a particular condition is not been fulfilled, then the contract can stand cancelled. And if a warranty is not been fulfilled, then in this case the contract does not cancel, but only the small changes or replications in a product or a service can be undertaken. Now let's summarize what we have learned in this particular session. In this particular session, we have understood what do we mean by warranty and what do we mean by guarantee. We have also understood which are the warranty and which are the guarantee contracts in respect of goods and respect of services. And lastly, we have understood how do we implement the warranty and guarantee and what are the various compliances as to the legal perspectives in the guarantee contract. So here let's summarize that the guarantee and warranty contract is essentially required, and it has to be seen as to whether it is a condition or whether it is a warranty, whether it is a main purpose or whether it is a collateral purpose. I hope you must have enjoyed the learning at this particular session. Thank you for your patience listening. Thank you.